ISPE. And as usual, I just have a few reminders before we get started. You all received a link to the quiz in the email that contained the registration link you got to get here. Please make sure to complete this quiz no later than Sunday night. I will spend the first part of the week grading quizzes, and PDH certificates will be mailed out approximately 1 week from today. Our presenters today are Paula Dixon and Reid of Holmes Murphy, and they will be presenting a primer for project representatives. Reid and Paula, if you want to get started.
Great, thank you. This is Paula Dixon. You'll be able to recognize my voice, and Reid, let them hear your voice.
Good afternoon.
That would be Reid. Okay, it looks like, who has control of this, us or Courtney?
Us.
Okay, cool. All right, so you'll see in front of us, we've got the politically correct male, female gender there, one representing Reid, one representing myself, and we'll assume the other one is you. So we're going to touch on the topic today of project representation. There's actually a full-blown course that Reid and I have traveled around and have provided that has specific exhibits, things related to more perhaps of the day-to-day. But what we want to, please feel free to send us an email if any of you would like to see some of the exhibits related to some of the hands-on things that you do through a project rep or doing a construction administration services for your project. We recognize, let's just go ahead and move forward to the next slide, that we're going to look at assessing some of the construction observation issues that we stumble into, understand what the risk and rewards are, and then direct you to some of the risk management tools and techniques, and then consider from an action plan standpoint where perhaps that offline we can even give you some of the resources, or you can go through ISPE to give you our contact information if you don't have it, and we could assist you with maybe some of your specific questions. We recognize that some of the information we're going to go through may not be exactly what you're doing. We recognize, as an example, with the Department of Transportation, that some of the things that they will expect for you to do, or if you're doing fully just the CA services and not the design services, that there sometimes can be a difference of the approach and what the expectations are. So as we go through this, we'll certainly kind of try to address infrastructure, vertical versus horizontal, but recognizing that sometimes what your roles are can be varied depending upon the type of client and what they mandate for you to do versus what you may be able to somewhat offer and get acceptance from the client. Let's go to the next slide, Reid. So we're going to work in a quiz process here. We find that it helps jog your own decision-making a little bit better. And I bet that some of these same questions may be the questions that show up on your quiz later. So this should be somewhat easy for you, hopefully, to make sure that you get all your continuing education hours. So our first question is, because construction observation carries with it the risk of responsibility for on-site accidents, design professionals should consider declining to perform these services for their clients. And the answer to that question is false. Many times in the past, years ago, we had some of our clients actually instructed. When I say in the past, I go back to 20-some years ago, especially in the state of Illinois, with the Structural Work Act, that the taboo or the fear of construction observation was so great that there was actually firms, believe it or not, I'm showing my age here, that told individuals that if you see a problem on the site that relates to safety or conduct related to what the contractors are doing, keep your mouth closed and get off the site as quick as possible. If an accident occurs, get off the site as quick as possible. If you can avoid actually even doing construction observation, try to do it. And those are all essentially myths from the past. What we know statistically from what we hear from the insurance carriers is the opportunity to perform the construction observation, the things that we actually see on a day-to-day basis. There's much more positive that comes out of that than what we see on a smaller scale, which is actually job site safety issues. Of course, the job site safety issues create all the flash as far as in the newspapers and the media, but we're very fortunate that really that's the minimum. My minority of the activity that we see on a day-to-day basis. So just as far as supporting why we should do construction observation is that it gives us an opportunity to make sure that the completed construction is actually in general conformance, you'll see that word used some more, with the contract documents. It puts you in a position out there that if the contractor does have questions or they need clarification on your construction documents, that you're able to provide some of that information to them, certainly not directing them what to do from a means method standpoint, but at least being able to clarify that while they're in the field and can address some of those things. And catching those trouble spots in the design. None of us are perfect, and sometimes there are modifications that have to be made out there, and it allows us to resolve some of those things quicker and at less cost to the owner and grief with the contractor later. Next question, Reid, this one's yours.
Ooh, yeah, question 2. If my client doesn't want to perform construction observation, there's nothing I can do to reduce my risk. And of course, the answer is false. Now, it's always in your best interest if you perform construction observation services. But if you can't persuade your client of the value of those services, here's some steps that you can take to take control of the additional risk posed by the design without the construction administration services. So number 1 here, consider charging more, not less, for design without construction observation. The additional charge reflects your added risk in not being able to perform this critical step. Show in your work's excluded services, your anti-scope, I hear it referred to more and more as, show in those excluded services section that the owner has specifically declined your construction phase services. Consider including a limitation of liability clause in your contract to limit your liability to a specific dollar amount that you and the client can agree upon. Obtain contractual protection in the form of a waiver or an indemnity from your client. I'll show you what these type of contract provisions might look like on the following slides here. So this client is responsible for observation. What this basically says is that that's exactly it. The client is responsible for the construction administration. It also says that the client won't make a claim against you connected to the client's interpretation of the contract documents or for construction observation. We thank Excel for this sample language here. Excel Specialty, the carrier, of course. This language, this is good for claims against the owner. What about your third-party claims? And we'll look at that language on the next slide here. So here's how you can try to protect yourself against third-party claims. Get an indemnity from your client. To indemnify means to make whole. Here, in this contract language, the client agrees to indemnify or make whole the consultant if there are any claims arising from the modifications, clarifications, interpretations, adjustments, changes, anything else made to the contract documents. That means if there's a judgment against the consultant, the client will pay it. The indemnity also calls for the client to pay the consultant's cost of defending itself. Indemnities are a really good idea, and you should try to incorporate them in your contract when you face a heightened risk, such as design without construction observation, condominiums, those type of higher risk projects. Just remember that an indemnity is only as good as the pocketbook of the client or the indemnitor. If they have no money or have gone out of business, the indemnity does not offer any protection whatsoever. So this doesn't mean you shouldn't try to obtain indemnities, but do realize that it's not bulletproof. Lastly, this slide basically says that even when you're not providing construction phase services, your client can request them as additional services. This language makes it clear that you are not performing construction phase services while leaving the door open in case you are successful persuading, selling your client of what you already know, that construction phase services are in their best interest.
Question number 3. It is appropriate for the architect engineer to contract to perform construction inspection services. Keyword being inspection, and the answer is false. Go ahead and move forward. Back in the day, here I am, still like such an old soul here. The term, I'll be honest, the whole thing with the inspection word terminology, we've seen great improvements, I would say, over the last 15 years of not seeing the word inspection come up as much in contract terms. I think we sometimes still stumble a little bit more in our own oral or our verbal communications with clients, but certainly the word inspect, the judicial interpretation can get us into some difficulties because it would actually mean that we're monitoring every detail. We're actually willing to assume the liability of those contractors' errors, and it puts us somewhat more into an inspector mode similar to product liability. Certainly we're familiar sometimes where you open a product and it lets you know that Inspector 12AB has looked at that product before they send it out. And we want to remove ourselves from somehow giving some type of a product back over to the owner, which is what an inspection from a legal standpoint would imply. Now, again, I referenced the DOT, actually the railroad. Sometimes we see this, we stumble into it with the DNR, is that you either provide inspection work or they're not going to hire you. You're not going to be pre-qualified. And if those, I will just step offline of our material and say that we would encourage you then to make a business decision looking at who the client is. A client such as DOT or the railroad, the implications of using the word inspection is going to be much different than if it were a developer client that would pursue you, chase you, whatever, because of the higher standard of care that they would be requiring. So all that being said, we still need to be very cautious of using the word inspection or calling ourselves an inspector. And let's learn a little bit more as far as what we are actually doing and what the appropriate description is. We want to use the word observe. Much of us will see in the industry that it's construction administration, we're a project representative, we're a construction observer, we're doing construction review. Much softer words that we utilize in trying to find what we're doing. The key is, even if you're not that guy, that gal, negotiating the contract, I think it's beneficial for our individuals that we put out to the job site to read in writing about what are we actually supposed to be doing out there. What are we going to be held to the fire to later if there's a problem that occurs on the project regarding the completed work or perhaps the conduct of the contractor. And let's look at what the detail says in the contract language as far as what we're actually doing. So what is observation? And if you look at the word up here, it's basically saying that we're going to observe the progress and quality of the work completed. That's standard language that we would see in an AIA document. We'd see that in an EJCDC document, that we're essentially reviewing, observing, checking out what the completed work is. What it isn't, and you'll see this in some standard language, is it's getting us away from the inspection role. And that is, we're not there doing an exhaustive check or detailed inspection, but that we're trying to just generally, and follow that word, generally familiarize ourselves with the work to see if it's in accordance with the contract documents, so that our role would be that we will, moving on to the next slide, we're going to endeavor to guard, protect the owner against these deficiencies. We are their agent, their representative, we are their advocate, we're their eyes and ears out there to try to bring to their attention that if the completed work by the contractor that they hired is not in conformance, there's a faulty workmanship issue that could or is in the midst of pursuing, that we're going to bring that to the attention of the client. If the client desires something greater than that, they say, you know what, I do want you out there reporting everything, I want you more involved, and that's where, and we don't necessarily see our clients being engaged for this, but then you have a conversation about additional services. If it's a full-time project representative that you desire of us, if you want us more in somewhat of a construction management role, then let's talk about that with the client. Just trying to help you think about scope. Instead of just fighting back and forth with the client about the actual contract terms itself, let's move forward in that conversation with them to say, from a scope standpoint, what is it that you desire for us to perform? What are your concerns? What has been your exposure out there in the past with working with other contractors or architects and engineers? So that if they desire a higher level, then sure, if they want to pay us that fee, we'll go ahead and provide that as an additional service. clarifying in that contract language, too, is what we're not performing. And this is really, really key language, especially in the state of Illinois, because of the Structural Work Act, to attempt to further memorialize to that client in case there ever is some site of a conflict that occurs out there, that we're being deliberate in saying, and especially to them from a scope standpoint, we are not your person. We're not your guy. We're not your gal that is responsible for construction means, methods, techniques, sequencing, or procedures. That is the contractor's role and the role related to the contractor to protect the site for those that go onto the site related to safety. And we'll talk about safety more here in a bit. But for now, trying to be very clear of this is what our role is as an architect engineer and what the role is of the contractor. Stepping outside of our role by actions could get us into some trouble above and beyond if we've got this great contract language, but then our actions, we start doing things that could be interpreted different than what we put into the contract. And then just one finer contract clause, we're all about this language, again, just indicating that we are not responsible for the acts of the contractor, any entities performing that work, and that we're not guaranteeing the performance of the contractor is ability to work in accordance with the contract documents or laws, codes, or regulations. So that brings us up to the next question. Now that we've tiptoed around, we're not responsible for safety. Reid, why don't you take question number 4?
Sure. So if an engineer has good language in the contract saying that the engineer has no responsibility for safety, means, or methods of construction, then a court can't hold the AE responsible for job site accidents, right? This was false. A well-worded contract is only the beginning. You can throw away all the protection afforded by good contractual language if your actions contradict the words of your contract. If, for example, you go out to the site and play safety cop, you're offering gratuitous advice about the safety to the contractor's employees, a court may very well decide that you have assumed responsibility for job site safety. You're virtually expanding your scope of service by your actions. You must not only talk the talk by having a good contract, but also walk the walk and make sure that everything you do on site comports with the language of your contract. By the way, note that you are responsible as an employer for safety of your employees on the job site. Construction sites, by their very nature, are very dangerous places. An employee of a design firm is injured on a job site is fairly rare, although such injuries do happen, and those injuries are covered under the workers' compensation coverage carried by your firms, your employers. But directing anyone else in regard to safety is really opening the door to an injured worker claim that can be really bad for you. Moving on, question 5. Paula? Okay,
so we've made this sound simple, but it really isn't that simple when you talk about job safety. So we've all dealt with this or heard of someone that has had situations. So if I do see a dangerous condition on the site, I should just ignore it, right? Kind of sounds like what Reid and I are saying. That's not your role. It's somebody else's. So should I just ignore it? And the answer is false. It is a safety dance. I kind of call it the Columbo method. Asking questions but not telling any answers is somewhat what activity occurs. So essentially the steps to go through on this, as you recall up front, I mentioned that in the old days we just said run, get off the site as quick as possible, act as if you didn't see it, you weren't there. But if we do come across an unsafe condition that requires immediate attention, sometimes you'll hear us use that there may be some form of imminent danger. We do not tell the superintendent how to fix it. We don't instruct them to stop the work. We don't tell them what to do. But we basically go forward and have the conversation with the superintendent, basically asking some basic questions related to that we're not responsible for the unsafe condition. Are they aware that we saw something there or this may be occurring? And you're hoping that they will actually take action and do something about it, and then you can move on and not have to worry about it. But the difficulty is that that superintendent turns to you and says, you know what, I've got a reason for doing this. I've got a time crunch here. I know that the pathway that we're bringing those materials in could potentially be risky to the bricklayers laying the block or whatever, but this is the way it is. Go back to your work. That becomes difficult if they choose to ignore maybe some of the safety violations that are going on out there. So it really puts us into a position, and of course I encourage people, this is why you have cell phones, is to get some further input from perhaps somebody that may be in more of a senior role from your office that has had experience, maybe knows more history about this contractor. And of course the things that I'm suggesting is that you have time to consider this. If there's imminent danger, I mean that's certainly a whole different issue, but it's some of the slightly nuisance things, an open area or other pretty obvious maybe trench issues as far as shoring is concerned, that perhaps you're seeing that the contractor, the superintendent, is totally ignoring what is appropriate to be done. Now, the still nothing piece, you certainly cannot just write down in your field log book that I told the contractor, and then if you do not pursue and do anything with it, and then later there is a problem, it shows that you created documentation but didn't take the proper steps. We've actually had a journal before that said the wall fell just like I thought it would, and they recorded that in the journal. We have to consider that whatever we write in those daily field reports or our log books, that someone later could pull that information and we could be measured upon or weighed upon with what information did we have, what actions did we take, what would another professional have done under the same situation. So one of the things that's key, and I would encourage you if your firms don't already have a sample letter, is that you have something like this that you can pull from, that once you've asked the Columbo questions, you've done the safety dance, hey, Mr. Contractor, do you feel that this is safe? This appears to be an unsafe condition, and seeing kind of if they're going to take care of it. There still is the next steps that once you put yourself involved in this, and hopefully you do that only on a rare basis, then you have to thread this all the way through. And that means that you then take the next step as far as notifying the owner and kind of cleansing yourself from this. And here's a form letter that that has been provided to us that gives you that has somewhat of a blessing on it with what that terminology or that format would look like if you actually sent that to the owner. So what if there actually is imminent danger? The imminent danger being defined as, holy crap, that scaffolding is going to fall, the trench looks like it's about to collapse, and somebody is going to be dying immediately or being seriously injured. These are difficult things, and we don't want to in any way lead you to believe that the cruel, cold insurance people are saying run off the site and don't try to protect somebody's life. Certainly on the 10 o'clock news, we don't want you to be in a position to know that you could have protected someone or brought attention to someone and that you didn't take action. So if you see something that is imminent danger, we want to make sure that that if it's necessary, that we do bring that to the attention of the person and try to assist them to protect them from harm's way. Okay, question 6.
A project representative should not participate in safety discussions during construction progress meetings. Of course, this is true. Don't participate in the safety discussions. Excuse yourself from the room during safety discussions. If you're in charge of the agenda, put safety last on the agenda so you can do this easily so you can leave. That's just silly, you say. Well, here's a good example of how one job site observer saved his firm several $1 million due to his careful attention to walking the walk, so to speak, including leaving the meeting during safety discussions. So here on this project, the design firm's on-site observer went to great lengths to make it clear his firm had no responsibility for job site safety. This person would excuse himself from the project meetings when safety programs or issues were raised, and he would even go so far as to note to the person taking the minutes that he would have them note the minutes that he has left. He would also ask that the safety issues be held until the end of the meeting so he could excuse himself. And his actions brought ridicule upon himself and from others attending the meetings. If he received transmittals relating to safety programs or issues, he returned them with a note advising the design firm was not responsible for the job site safety issues or programs. On this particular project, a collapse did occur. It killed 2 workers and severely injured several others. The inevitable lawsuits were filed against everyone involved in the project, including the design firm. Now, this design firm was the only defendant to successfully defend itself and paid out nothing, while the other parties paid out over $20 million in jury awards. So thankfully, this design firm had a person on site who understood the critical nature of job site responsibility and has the strength of personality to disregard the ridicule of others and follow the correct procedures or the procedures put in place by his firm. His strong actions saved his firm a huge amount of money as well as his firm's reputation. Number 7.
Here we go. Okay, so this one's a tough one. Your firm's ability to defend against a claim is likely to depend in large part on the quality of the records you assemble and the notes you prepare. True or false? The answer is true. Okay, so here's the interesting thing. We've heard for years, document, whoever has the most documentation wins, bring in boxes and boxes of paperwork. You know, this is our livelihood, just CYA ourselves all over the place. Well, some of the background data that's troubling to us is that due to the inexperience of either the project managers or the inexperience of presently the even the owner's representative, is that inexperience leads to finding that people don't know what they don't know. So if you don't know what to document, I have no idea how you would know what to be putting into your field reports or what to be concerned about. What's interesting about this documentation piece is that also, I'm just full of statistics here, but as far as what drives the claims, about half of the problem is us. And you know, we'll step up and we'll acknowledge that from a design professional standpoint, we're not perfect. But what's interesting in the new data that's out there when it's been more detailed is that the other half of what goes squirrely on the projects is related to construction budgets, construction schedules, faulty workmanship, and that we in the design community are drawn into those claims cases because basically less than 0.5% of the claims, or less than 5% of the claims, actually go to trial, which means we negotiate the settlement agreements between the owner, the contractor, and the design professional. And we do that because it's less costly than litigating it. So no one feels like a bunch of testosterone flowing and excitement over going in and settling, basically surrendering. But sometimes it ends up to be the best long-term business decision to make with the cost it takes to try to take the firm's resources of defending these claims or paying the legal expenses to get there. So keep tracking with me here for a moment. One of the other things we hear people in the AE community is that, well, you know, it's not our fault. We're stuck with working with these low-bid contractors. And we agree with you, and we know that's the nature of the beast. If we choose not to work with a low-bid contractor, we won't be on much of the projects that we are engaged or awarded to work on. But with that, it reinforces why it is so important that we're documenting the right things going on out there, that we're putting in those field reports and getting that information back to the owner as far as what is going on with the construction budget, the construction schedule, the things that we're hearing about. We assume that later they'll say, you know what, that was our contractor, we hired them, we'll step up and we'll pay for these change orders and some of these conflicts that we have now in payment. But sadly, folks, we're telling you that over half of the claims that we get is where we are participating in those conflicts between the owner and the contractor over time, schedule, and workmanship. So including in that, we're going to talk a little bit about those field reports. They're so important for what comes out of your project rep duties because it's our only opportunity that we can show continuous conversation or communications with the owner about what we're observing. There's also one piece further before this, and that is in a documentation standpoint, if we're getting involved with even having a pre-bid meeting where the contractors that are going to bid have to attend, and that we're documenting what information was presented to them before they actually pursued the project itself. Again, trying to protect ourselves with the right documentation so that we're not drawn into those claims. So here we go. The routine documentation, this is not going to be shocking for you, and I'm recognizing that some of you are in positions that the owner mandates what you're going to be filling out. Where we get ourselves a little bit more sideways is when the owner decides to engage us only for periodic construction observation, or you get 4 site visits, and you have to come up and identify when those 4 visits should be or when these periodic visits should be. And if we don't have a standard format of what we're to record or what our role is, our scope is when we're on the project site, that's when we get ourselves into some trouble. Okay, so here's some routine documentation. We want to have some standard forms so that we're being consistent within our organization. What's interesting is those good old handwritten logbooks are still favored over back in the day. There was, let me jump in the truck, I'll do this with the voice, what's that called, where you, then you, a voice memo, and then you would have a secretary or something actually type that up and send it out to the owner. We still find that the strongest evidence is that good old nasty paper field reports with your cigarette stains and coffee dripped all over it, where there's different pen writing. But the key is that there's something that really is a working document that shows your activities and that you are out there watching. Okay, so let's go further. Information that you're going to want on that, we do have sample documents. I think the key for you is just to scan through this and think about, one, do we have a standard format that we use if we're not using the DOT's or somebody else's? And does our standard form include all of these different bullet points? I could read them all. That would definitely get us all up to 1 o'clock, but I might bore you guys. But going back and looking at our own internal documents and weighing against that to see if we are getting sufficient information in those and sent back out to the right people. But speaking of the right people, who is supposed to get the actual field reports and get copies of them? When we ask this question in open seminars that we deliver, it's interesting that people are kind of all over the place with that. That goes back to, let's clarify that in the pre-construction meetings to find out who is supposed to be getting these field reports. Because it seems kind of silly if that just gets sent to the owner and we don't know the time lapse between how much and how long that's getting communicated back to the contractor. The other question is, how often should these progress reports be going out? And we do see delays, again, in the field reports actually getting processed and sent out to the owner. Traditionally, the window should be somewhere within a day or two after a visit. Certainly here you can see the different things that should be documented. Again, reach out to Reid and myself. We've got a couple samples from our actual clients that show the amount of detail that should be in these reports. Specifically this area of unresolved items or particular points that are collected at the job site visit where it appears that something is not in conformance and how to appropriately document that in that report. Now this issue of photographs and videotapes, obviously we're a little bit aged on the word using videotapes. We now have access to being able to take photographs more now than ever in our generation. And because we can, we have become the paparazzi out there. We are now where we almost have to ask you to kind of pump the brakes a bit, in that we are getting ourselves actually into trouble a little bit with taking pictures of stuff that later, when our records are subpoenaed or that we're releasing, that some of the things that we should have noticed on the site end up being used against us because we have it in a photograph, and we may say, you know what, we are out looking at this, at the rebar or something, we weren't even looking at that over there. But because we have it in our records, it can create at least a storyline for the plaintiff attorney to come after us. So we just encourage that if we're taking photos that we're deliberate with what we're taking, that we're more cautious on doing any of these aerial or whatever they're called, the ones that are horizontal. There you are, panoramic photos. That we limit those for whatever the intended purpose is. And we also just caution you, you're such good folks, you're kind, you're serving. When the owner calls you up and says, you know, we have a conflict with the contractor, this isn't about you, but we'd like you to release your records for us because we have an issue going on with the contractor. You're such nice folks that you release your records without perhaps cleaning through them or finding out more information, and sometimes we basically show our poker hand where it's kind of like a domestic dispute where one thing they always tend to agree on is that they always dislike somebody else except each other. So it ends up that they draw us into it from a design professional standpoint, because then everybody feels a little bit better if we just say everybody was equally at fault here. The final thing, ignore this videotape thing, but there's something that's a current trend out there. I think the product is called Multivista. I may have it wrong, but I call it a nanny cam. And basically there is a vendor out there that will solicit the owner and encourage them to basically put this 24-hour, 7 days a week, kind of like a security camera that will view the construction site. And you know, I don't know if that's going to be good or bad. Maybe it could be good between the owner and the contractor. But what we have to caution ourselves on as a design professional is that if they give us the password, or they being the vendor on behalf of the owner, or if they are threading or sending these pictures to us or the video, that we refuse that. In other words, we're either going to review that as an additional service and then clarify what we're reviewing it for. At this point, I've yet to see an owner want to pay one of my design professionals to sit there and watch all that stuff. But if we allow that to be sent to us, we're essentially verbally raising our duty of responsibility, that we're basically expressing to them the intent that we are looking at that material. So we need to be proactive to make sure that they understand we're not looking at that stuff and we don't want that stuff. Okay, let's move on to question 8. Reid.
A project representative's field log can't be admitted into evidence in court. This is false. Some people think that because the field log is handwritten, it can't be admitted into evidence. As Paula kind of alluded to, nothing could be further from the truth. Actually, because your log is typically handwritten on the site, as things happen, it can be very powerful evidence for you. But you want to make sure it is powerful evidence for you and not against you in the event of a claim. So keep it factual. Facts belong in your field log. Personal feelings and comments have no place in your field log. Keep it professional. Your professional opinion belongs in your field log. I guess the rule of thumb is if you don't want it blown up on CNN or on the front page of the paper, don't put it in writing. Keep it contemporaneous. This is a $12 word that basically means that you should write your field log at the site, not a few days later. If you write it at the site, it has greater power as evidence. If you try to remember it later, it loses much of its value, and it's likely to be inaccurate, and it could be incomplete as well. Keep it clear. Your writing should be clear and concise, not subject to many different interpretations. Also, keep it as legible as you can. I know Many of you may be out there like me that actually looks like we write like third graders, but do your best to keep it as legible as you can. Keep it clean. Again, it should go without saying, but I'll say it again. This is no place for bad language, remarks about others' genders, race, country, origin, other remarks that will appear later as evidence that you were not dealing with the contractor or others in good faith. And think about how your documentation would look blown up on the screen and shown to a jury. Much like, as Paula alluded to with the pictures, the photographs, be very specific about what you're photographing, what you're documenting, because once you blow it up on a screen at 20 times the size that it was before, it makes a little bit bigger difference. So is that going to be Exhibit 1 for you, or is it going to be Exhibit 1 for the plaintiff?
Before we move on, Reid, let's just share for a moment a couple other trends, and as it relates to communications or dialogue with the owner, contractor, and design professional. We had our first, and bear with me guys and gals, I am not a social media expert here, but a first Twitter claim, I think it runs back now 2 years ago, up in Wisconsin. So we'll pick on the cheeseheads. In essence, where things got pretty casual and sloppy as far as the communications on the project, and the owner and the contractor, and I guess, this is common with kids going to college now, that the information regarding school assignments, security issues, I know it's very common that is a way to broadcast information out, and it's successful. But as it occurred up in Wisconsin, with this started to be kind of the cool thing to do, it ended up being disastrous for us, just because of the sloppiness, the abbreviated versions. I don't know how you slash tag, bring the steel in and put it down here, but nonetheless, whether it's Twitter or
text messaging,
texting has just become outrageous. And again, we're not hating on technology. We're just encouraging you to stop. It doesn't have a place in the construction industry that craves so badly proper documentation, proper communication, and I mean clear communication, thought-through communications versus through text messaging. It's dangerous if we're doing it to the client itself, and it's very dangerous even internally, because if Reid's gone and traveling, I don't have a way to collect the communication string that he had with one of our clients if that's all on his iPhone through text messaging. And I know this sounds like a silly thing to talk about, but it's really become a pretty dominant problem with the looseness in exchanging information back and forth between internal customers and our external customers. Anything else you'd add?
Yeah, I would just add, just be very specific in your communications as well. If you are texting, Twittering, Facebook, all that stuff, document. Be very specific about what you're responding to. There was a claim that arose for an engineering firm in California. A client sent them an email and said, hey, is it okay if we substitute this material on this particular part of the project, and do you want to go to lunch on Wednesday? So the engineer replied in his email, yes. So wouldn't you know it, a claim came up in the amount of, I think it was about $250,000, $250,000. A claim came up over that substituted material. The engineer said, no, we never approved that, the use of that substitution, anything like that. Well, turns out when they sat down to mediate that particular claim, he pushes the email right in front of him and says, hey, here it says you approved the material here. It says yes. He says, well, no, I was saying yes to lunch. So again, be very specific about what it is that you're responding to, because that yes in that particular email actually ended up costing the firm $250,000. So be very specific about your communications.
Okay, we are coming up on to question number 9. By the way, there's 10 questions, so pretty exciting here. It's a good idea to have the project team review the contract before the project begins. The answer is true. The real question, I suppose, though, is that really what happens? what we find typically is that the individuals that negotiate the contracts on behalf of the firm don't necessarily pull that information back down to the project team to let them know where we kind of sold our soul within that contract. If you send a contract to Reid or myself or any of our other service team at Holmes Murphy, we'll comb through it. We'll tell you where there could be some potentials for insurability, and so that you can use that information to make a business decision. The key is, though, is if that business decision is, you know what, I think we're going to move forward. We know what our risk is. Now we just want to manage that risk. We really strongly encourage you that risk is then managed by letting your project team know what you just committed to in there, especially if it had something to do related to code issues, time issues, so that the project team can be more aware of those things, and then going back to the documentation so that it's more clear about what they need to be noting so that we don't later get into trouble. So back to saying before, the inexperienced didn't know what they didn't know. We're going to reinforce it's good to know what you are doing. So let's just face it, contracts are tedious. I'm not suggesting that you pass down a full contract to the project team, but I am suggesting that you at least highlight, have a process that you're identifying some of the key issues. Doing only what you have contracted to do. Now that sounds pretty obvious, except, again, you're nice people. Scope creep is something that happens pretty easily, where the client will ask for a little bit more, ask for a little bit more, ask for some more reports done, ask for more reviews done, ask for more opinions. And because you are nice folks, you don't feel like, oh, I don't want to nickel and dime them and tell them that's an additional service. Or to offer them an opinion that you know you probably shouldn't be offering and they should go back to the contractor, or a legal issue that they really should go back to their proper legal counsel. So we just encourage you to think about what your boundaries are, your scope, and then start from the first or the second request that's above and beyond that to make sure that the owner knows that if you are doing them something that's above and beyond your basic services, so that you later don't get into some internal fee budget issues. Do not go to the site if you're not contractually obligated to. This particular advice to you, I know, could be if you had your phones not on mute, we would have some dialogue about some people strongly believe that even if the owner hasn't contracted them to go on the site, they're like, you know what, it's my job, I'm the engineer, I'm going to go check out the site anyway. I just want to caution you as far as a camaraderie with the contractor. If you show up at the site and you're not hired to do the construction administration services, and you're unwanted or throwing around advice if you weren't hired for it, the contractor is responsible for the site. So we want to make sure that we are a friendly visitor if that's the case. The difficulty is, though, once we do go to the site, we have contract language that says we're not responsible for construction-based services. We have now broken the seal that whether it was that time or other times, that we have now raised the level of duty to the owner that can also draw us in if later there is a schedule problem, there is a workmanship issue because we were there. Do not go to the site if you do not know the purpose of your visit. And I referenced that before. Again, we do a pretty darn good job when we're told what to do and we've got our little checklist. Things get a little fuzzy when we have our token 3 visits. It's still very key that we tell the owner or give them a sample that we're going to go out there for our 3 visits. This is the times that we think are key that we should be out there, and this is what we're going to be performing. Here's our checklist. This is what you can expect from us from a documentation point. Because if you don't have clear boundaries of what your purpose is and what you're doing while you're out there, even if it's on your 3 to 4 visits, they're going to assume that you have now just picked up and caught up from all the other 9 visits that they weren't willing to pay you for, that you're going to just combine them all into one and get their money's worth. So you need to be clear with what you're going to be doing once you're out there. And of course, it's obvious. All of us, maybe you guys have better memories than me, but certainly more important when you jump back in that truck to start recording your observations, even more important before you leave the project site, that you even share with the construction superintendent. This is some of the things that I observed today. This is what's going to be in my report. In a friendly way, might as well let them know now versus perhaps later, especially if you're going to potentially not approve a payment submittal because of something that you observed out there.
With that, we're on the last question, question 10. The job site is a great place for new engineers to learn the ropes. True or false? It's a trick question, it depends. Oh. So it's false in the sense that it's time-honored tradition to send the new guy or new gal to the site, but if we send them alone, it's a really bad tradition. So just think about the importance of all the tasks we just discussed. Important to the success of the project, to the profitability of your firm, and to your ability to defend against claims. So do you really want the new kid on the block in that role? It may not be fair to the new kid and a potential disaster for your firm. Or it can be the right way. True, sending the new kid with an experienced construction observer is a great idea. Think about all the stuff you didn't know on your first visit to the site. Where did you go first? What did you look at? How did you talk to the contractor? What did you document? Watching an experienced person is the best way to learn in this scenario.
Okay, wrapping up then from an action plan standpoint, we're not going to do an action plan. We're just going to ask questions. As far as the things that we've gone through today, I recognize that much of this probably isn't new information, but I will share with you when we work individually with firms, the feedback that we get is, really many of us may be put into doing site observations based on what we think we're supposed to be doing out there or what we've watched somebody else do in the past, and that isn't necessarily the best approach. So what we've heard from other firms is just kind of looking at what are their training procedures, what are their mentoring procedures. Just because Bob Jones has been doing it for 50 years and he's retired DOT doesn't necessarily mean that Bob Jones is doing, Bob Jones may be doing everything consistently risky for the last 50 years. But that we're really looking at some of these liability things. And again, the way that you folks are wired, you're such nice people that what seems to be the obvious thing to do out there to help things and to try to avoid problems sadly suck us into later, getting us into more liability by drawing us into that. So training, mentoring is one of the things that we've heard from others. The other piece, feedback that we've had is really just a consistency of procedures. That you know how to do it with one particular client, but things kind of get a little bit goofy when we have a little bit more gray area about what we're supposed to be doing. Consistency also from the standpoint of having good, clear field reports and that we're conducting those site observations the same way every time that we show up at the site. Another thing, just this feedback that we've had and that we've experienced from actual claims is that professionalism piece that Reid had spoke on before. It's kind of sad, but I actually saw this in one of my large firms' project rep manuals, that they said, you are not out there to win back homecoming king status. In other words, it's not a popularity contest. I did think that the construction observation role was really more of a public relations piece, that it gave the engineer the chance to go out there and show the love to the owner, to the contractor, to the project. But there really is a key role, and in that professionalism piece, that you have, as far as your clothing, it's identifying who you are, what firm you're from. You show up in your truck, you identify that you're there, you do your stuff, fill out your report, you get back in your truck, and you leave. Again, that whole, it's not there, your role isn't to become the homecoming king, in that we don't hang out, we don't smoke cigarettes, drink coffee, go to lunch, and watch the construction as it occurs, like we drive by on the roads and see that it takes 4 guys to watch 1 guy do the work. We want to get to the site, do what we're supposed to do, and and get out of there and be consistent each time. Reid, anything else? Now, do we have the ability to take questions? Is Courtney going to send something?
Yeah, we're really kind of wrapping everything up here, but Courtney, did we have any questions from any of the participants today?
I have not received any questions yet, but if people want to submit them now, they can.
Okay.
You would do that through the question module on the side of your GoToWebinar.
Okay. Well, we'll give it a couple of minutes to see if any questions come through. We're very happy to answer those. In the meantime, we're very thankful to the ISPE and the opportunity to participate in the webinar today. And as always, if Holmes Murphy or Paula or myself can be of any assistance to any of the participants, you're too shy to ask a question in this forum, feel free to give us a call, drop us an email. If we mentioned any exhibits that you wanted to take a little bit closer look at today, drop us an email. We'll be happy to send those as well. But we certainly thank you for the opportunity.
Well said. Thanks, Reid.
And thank you guys both very much for taking the time to present. I haven't received any questions, so
let's cut them loose. What do you?
What's that?
Shall we cut them loose?
I think we probably should.
All right. Thank you. Happy New Year. I think we only got one more week till we can keep saying that, right? Hopefully you got your Christmas tree and decorations down. It's time. All right. Thank you, everybody.
Thank you guys very much for presenting. And just as a reminder to everyone, the quizzes will be out the quizzes should be completed by Sunday, and the PDH certificates will be out by the end of next week. Have a great day. Thanks for participating.
Thanks.
Bye-bye.